I will read the intro and then I will turn it over to our speakers. My name is Jeff Tronvold. I am a staff attorney with the Unified Judicial System and a member of the State Bar of South Dakota CLE Committee. Before we get started, I'd like to go over a few items so you know how to participate in today's event. But first, do you or another State Bar member or law student you know have a drug or alcohol problem or struggle with depression or anxiety? Lawyers Concerned for Lawyers is a confidential and independent resource for South Dakota lawyers, law students, and their families. Your referral or visit with the LCL is strictly confidential and privileged. Call Becky Porter for more information at 605-391-5191. Becky is an LCL member, and your communications with her are likewise confidential and privileged. You can also call 988 to reach a mental health professional or the Sand Creek Employee Assistance Program at their confidential crisis telephone line. That is 1-888-243-5744. Mental health professionals at both numbers are available 24 hours a day, 7 days a week, and we'll put those phone numbers on the chat feature of this Zoom meeting. Today's presentation will last approximately 1 hour. You will have the opportunity to submit text questions to today's presenters by typing your questions into the chat feature of Zoom. You may send it in your questions at any time during the presentation. We will collect and address them during the question and answer session at the end of today's presentation. Thank you to the State Bar of South Dakota and CLE Inc. for their support of today's program. I would now like to introduce our presenters. Bridget Hoffman is a native of Rapid City, South Dakota, and earned her JD from the University of South Dakota in 2018. Following graduation, Bridget clerked for the South Dakota Supreme Court, served in the Appellate Division of the Office of the Attorney General, and worked as a legislative attorney. She is currently an administrative staff attorney for the South Dakota Supreme Court. In her spare time, Bridget enjoys reading, watching movies, painting, hiking, cooking, and searching for treasures in secondhand stores. Sarah Thorne earned her JD and MBA from the University of South Dakota in 2009. She has served as the head of the Appellate Division of the Office of Attorney General since June of 2021. She practices before the South Dakota Supreme Court, the United States District Court, District of South Dakota, the Eighth Circuit Court of Appeals, and the United States Supreme Court. Prior to joining the Office of the Attorney General, she worked in private practice for nearly a decade. Sarah is a mother of 4 and an avid outdoor enthusiast. And with that, here is Bridget and Sarah for today's presentation.
Thanks, Jeff. Thanks for asking us to do this. We set up a little roadmap for today's content. I'm going to give just a brief overview of what an appeal looks like for those of you who don't regularly do appeals in front of the South Dakota Supreme Court. I have a few statistics put together regarding the 2022 year before the Supreme Court, kind of a year in review. Bridget is going to go over what is appealable, how to perfect an appeal, and how to avoid jurisdictional errors in 6 different areas of the law. We'll review the content of briefs and also discuss oral argument. And then Bridget will finish up with some tips for etiquette with the Supreme Court. All right, starting at the top oval here, this is kind of a bird's eye view of what a Supreme Court appeal looks like. After the notice of appeal is filed, the appellant will order transcripts from any pertinent hearings. Sometimes those can take 45 days or occasionally longer to receive the transcripts. After the transcripts are received and the record is complete, the appellant will formulate his or her arguments and conduct research in preparation to complete the appellant's brief, which is then served with the court and opposing counsel, at which point the appellee will then do their arguments and research to formulate the appellee's brief. And then the appellant will receive the opportunity to file a reply brief if that attorney so chooses. After that reply brief is submitted, you may or may not receive notice that you will have oral argument on the case. So it's the little outside bubble there. And eventually you'll receive the Supreme Court's decision, which can be in the form of a summary disposition or a formal written opinion. This is codified. Some people ask what the result of an appeal will look like. According to statute, the Supreme Court can reverse the lower court's decision. It can affirm. It can modify a judgment or order. It can direct a new trial, and the court can also basically direct the trial court to enter judgment as the Supreme Court determines. This is the section that is kind of some fun statistics that I really enjoyed putting together after looking at all of the numbers from the 2022 year before the Supreme Court. In 2022, the Supreme Court disposed of 153 cases. 81 of those were in written opinions, and the remaining 72 were summary dispositions. There were also 31 oral arguments that occurred during the year 2022. In days, when we're looking at the average turnaround for a written decision, the average right now or in the previous year was 219 days. The longest took 619 days. That one was actually, that was Miles versus Spink County Board of Adjustment. And that one was a CAFO, animal feeding operation permit case. And I think that one was on hogs. The author of that opinion was Justice Kern, and that was a unanimous opinion. The quickest turnaround, though, was only 16 days. That was Flint v. Flint, which was a child custody case authored by Justice Salter, I think, out of the Second Circuit. 8 years is the longest tenure of a current Supreme Court justice, and that is Justice Janine Kern. In 2022, 82% of cases were affirmed. In my mind, a huge testament to the quality of the judiciary in our state of South Dakota. And 28 out of 153 cases were at least partially reversed. 86% of written opinions were unanimous. That means there were 12 dissenting opinions total last year. Justice Kern had the highest number of dissents. She authored 7. And in pages, the average length of a written opinion in 2022 was 19 pages long. The longest goes to Brueggemann v. Ramos, which was a Butte County guardianship case authored by Justice Devaney. Keep in mind that 42 pages does include a written dissent from Chief Justice Jensen, and also a special concurrence in part and a dissent by Justice Kern. The briefest was a whopping 4 pages, real quick, in and out, Goins versus Dakota, abstract and title out of Brookings, authored by Justice Myron, and that was a real quick, we have no appellate jurisdiction in this case. That was one of 7 written opinions discussing jurisdiction for the year 2022. On the left, this table here, I titled it non-criminal case types in written opinions, mostly because criminal cases would take the cake on this. There were 23 written opinions on criminal cases in 2022, and 10 years ago, there were 27. So removing those, it's a lot easier to compare what types of cases are written on. This is a comparison from 10 years ago versus today, so that you can see in 2012 of a huge majority of family law opinions versus only 6 in this most recent year. That highest one for 2022, which I labeled county or admin cases, a lot of those were county drainage board decisions, wind farm decisions, and CAFO cases, which is interesting. But in 2022, there were 153 cases disposed of. 10 years ago, 179, so not a huge difference. And same with written opinions, 10 more 10 years prior to this year. And in 2012, there were 38 oral arguments. In 2022, like I said earlier, 31. And quickly, just topics that are frequently discussed in written opinions. very common to see summary judgment dispositions, which is no real surprise. The only thing real notable here is we talked a lot about wind and dogs in 2022. There were 3 written opinions pertaining to dangerous dogs, which I thought was interesting. Also, a lot of attorney's fees discussions. Sometimes, though, that's just even a quick 1 sentence stating that a request for attorney's fees or is not granted. Thanks, Bridget.
Okay, well, I'm going to talk a little bit about some of the more, I guess, kind of practical considerations to take into account in terms of mostly just filing the notice of appeal and how to make sure that that's properly done. So I'm going to talk about what is appealable, how to take that appeal, and how to avoid really big jurisdictional errors. And just as a little bit of a disclaimer, just want to note that my intention here is to provide general guidelines. It is your responsibility ultimately to know the rules and the case law interpreting those rules before you file a notice of appeal. So what is appealable? That is important because appellate jurisdiction is created by statute. And if that statutory permission to appeal does not exist, then the court doesn't have jurisdiction over that appeal. So beginning with civil appeals, we will look to 1526A3. Generally, we are talking about appeals from the circuit court. There's one example of an appeal that may be taken from the magistrate court to the Supreme Court, but I'll talk about that a little bit later. And also generally, what we're talking about are final judgments. And a final judgment has taken care of all of the claims of the case and disposed of all of the parties of the case. You can see that there are 7 different subsections here, so I won't be talking a lot about examples of appellate jurisdiction under each subsection. But generally what we talk about is a judgment that takes care of the whole case and leaves nothing left to do for the court except to enforce that judgment. So how do you take that appeal of right as provided by 1526A3? So look at the next provision here in 1526A4. I'm just going to hit the highlights here. This is a very dense, long rule that talks about a little bit more than what I talk about here. But generally, so you file that notice of appeal, and these are liberally construed in favor of sufficiency, but you need to specify the parties taking the appeal, the judgment order or part thereof appealed from, and it should be signed by the appellant or his or her attorney. A docketing statement is filed in civil appeals, and this should also you should attach the findings of fact and conclusions of law and memorandum decision to that docketing statement, and that docketing statement is a form that's provided by the court that's found in that chapter 1526A. This rule also establishes service on other parties, which I'll talk a little bit more about in detail in a second. And all of these items are filed with the clerk of the circuit court where the judgment or order was entered. And I'll talk a little bit more about how to make sure that filing is properly done. So first I'll talk about making sure that that notice of appeal is timely filed. And why is that important? Failure to timely serve and file that notice of appeal is a jurisdictional error. The time frame for taking that notice of appeal is provided in 1526A6. And basically it provides that the filing of the notice of appeal begins running the day after the notice of entry of the judgment or order was served, and then runs for 30 days. So there's a couple rules of civil procedure that you need to be aware of in determining and counting that 30-day time frame. For example, 1566A, if that period ends on a weekend, a holiday, or a time when the clerk of courts is inaccessible, the final day for filing is the first weekday that is not one of those days. We also have to take into consideration 1566E, and that is a rule that discusses if the triggering event for a time period is mailed by like first class mail, 3 days is added to the prescribed period. So if the notice of entry is mailed to the appealing party, they essentially get 33 days to take the appeal. Not something you see too much anymore with the Odyssey file and serve system, but it still happens, so it's still something to take into consideration. Depositing the notice of appeal in the mail does not count as filing. Filing does not take place until it is in the office of the clerk. But there's always fine distinctions to draw. Compare this to 1565B, which provides that service is complete upon mailing, and that relates to service upon other parties. So that is complete upon mailing, but that same principle doesn't apply to filing in the clerk's office. What else should be taken into account for timely filing? The time to take the appeal stops when a timely Rule 59 motion or a timely Rule 50B motion is filed. So those motions have to be timely for this sort of tolling to take effect. But when the time starts running again, when those motions are disposed of, or the time for the circuit court to act on them expires. So it's specifically only these motions that will have that tolling effect. For example, motions to reconsider do not have the same effect. And maybe what's a bit of good news, it's that notice of entry, the service of that notice of entry is what triggers the time period. So even if someone has actual notice of the judgment or order, the time period doesn't run until the notice of entry is served. So it could theoretically be pretty far down the road before the time for the appeal starts to begin until somebody files that notice of entry. So service of the notice of appeal. This needs to be done on all of the parties to the appeal except the appellant, each party. And this applies even if, say, someone was a named party to the appeal or was a named party to the case in the circuit court, but they didn't appear or they didn't participate. Nevertheless, they were a party that needs to be served with the notice of appeal. And the service rule is addressed in 1526A43. And it used to be the rule that only adverse parties had to be served with the notice of appeal, but that's no longer the case. It's much broader than that. The certificate of service is what provides the proof that somebody is served with the notice of appeal. And generally 1564G and 1565B indicate that that certificate of service has to indicate time, place, and manner of service. But it can be proven in other ways. It's the fact of service, not the proof of it, that gives a court jurisdiction. So now I'll talk about some more specific jurisdictional errors and other types of civil cases. So in abuse and neglect cases, this is something that can be easily overlooked. If a parent has had their parental rights terminated in an abuse and neglect case, and now they're coming to the Supreme Court to appeal, they have to sign that notice of appeal. And if they do not, it's a jurisdictional error. And that's provided by rule and has been explicitly been found jurisdictional by this court. Also, I know ICWA is kind of the constitutionality of ICWA is a pending matter right now before the US Supreme Court, but currently the rule is that failure to serve an intervening tribe in an ICWA case is also a jurisdictional error because that tribe is a party to the proceeding. But abuse and neglect cases do get a little bit of a break. While the Attorney General is supposed to get service of the notice of appeal, the failure to serve the Attorney General is not a jurisdictional error. Because generally, right, the rule provides the Attorney General and state's attorney should be served, but for whatever reason, Attorney General, failure to serve the Attorney General is not a jurisdictional error. Notices of review are treated very much like notices of appeal. So if you're an appellee and you have an issue you want to raise to the Supreme Court, you have to file the notice of review under 1526A22. And this needs to be complied with in order to get that issue considered. And the same jurisdictional requirements apply. It must be timely filed, and it should be served upon all other parties to the case. Discretionary appeals. These are provided for under 1526A36. So if there's any pretrial or intermediate order that an appellant would like reviewed, you can't take the appeal by rights, but you can petition this court in its discretion to hear your discretionary appeal. And these are generally governed by 1526A13 to 21. Again, the time frame for filing these is jurisdictional, and specifically, there's 10 days to file these after notice of entry of the order that you're seeking to appeal. But for these types of petitions, it is deemed filed upon mailing. So again, kind of one of those distinctions to be aware of. Because you have 10 days to do this, 1566A applies, and this rule provides that when the period of time is less than 11 days, you don't include weekends and holidays in that 10-day time period. So it's 10 weekdays, essentially. Service must be upon all other parties in the circuit court, and 1526A14 and 15 contain the requirements for the contents and attachments to the petition. And while not explicitly jurisdictional, if you don't comply with these rules, it is grounds for denial of the petition. And finally, motions for certificate of probable cause. These arise out of the petition for a writ of habeas corpus. And if the circuit court has denied that writ and the petitioner can then seek the certificate of probable cause within 30 days in the circuit court. If that's denied, the petitioner then has 20 days to file a CPC in this court. And 2127-18.1 is really the controlling statute. It addresses the entire procedure for seeking this. And the time requirements are not triggered by written notice of entry. It's purely triggered by the entry of the orders by the court. And the CPC is what gives this court jurisdiction over a particular issue in a habeas case. So if the CPC doesn't exist over that issue, if the circuit court didn't grant it or this court didn't grant it, then the court cannot consider it. Then the time requirements are jurisdictional, both in terms of filing it in the circuit court and in the Supreme Court. And service must be made upon both the Attorney General and the state's attorney. So turning to criminal appeals, I'm going to talk about these first in terms of what a defendant has a right to appeal, then appeals that both the defendant and the state may take, and then the appeals that the state may take. So appeals by right by the defendant, that's provided under 23A32(2), and the defendant has a right to appeal from a final judgment of conviction. And much like civil appeals, it's really just best to review the law and what is appealable under this section. Normally, we're thinking about the judgment of conviction. It comes at the conclusion of the case after a verdict or a guilty plea, and after the defendant has been sentenced. But for example, under State v. Brassfield, a order suspending the imposition of sentence is appealable under this section. And some more recent cases, State v. Kaufman and State v. Edelman, have done a lot more work to kind of interpret what sort of appeals a defendant may take. So I would refer you to those cases too, as kind of that really lay the groundwork for what kind of appeals a defendant can take in a criminal case. But nevertheless, what we're mostly talking about here are final judgments of conviction. So how do you take that appeal? That's provided under 23A 3216, which provides that the notice of appeal needs to be filed citing that judgment. It needs to be served upon the Attorney General and upon the prosecuting attorney of the county where the judgment was entered. And we've specifically held that the failure to serve the Attorney General is a jurisdictional error. The time for taking this appeal is 30 days after the judgment is signed, attested, and filed. So no notice of entry triggers here. And but there is the same kind of tolling provision for new trial motions. So appeals that can be taken by the defendant or the state, there is a discretionary appeal provision under 23A 3212. Generally the same procedure as criminal or as civil discretionary appeals. And 23A 3222 is also provides for discretionary appeals of illegal sentences. And again, these refer back to the procedures for civil discretionary appeals. And finally, appeals that may be taken by the state. 23A 324 provides for the appeals by right that the state may take. So these are very specific types of situations, types of procedural situations that the state may pursue an appeal. And again, like I said, they're a matter of right. They're not discretionary. 23A3216 would also apply here in terms of what needs to be taken to perfect that appeal. But when the appeal is taken by the state, of course, you just need to serve the defendant. But although these are taken by right by the state only has 10 days after written notice of entry of the judgment or order to take this kind of appeal. And finally, the appeal by the state of suppression orders or dismissal of complaint. This is a type of discretionary appeal. And this is the one way that an appeal may be taken from the magistrate court to the circuit court. This is the one example of that this court has established. I think that's the end of mine.
Thanks, Bridget. Thankfully, guidance for the contents of briefs is really clear and really explicit in statute. Keep in mind this will apply to civil appellate briefs as well as criminal appellate briefs. You need to include a table of contents and a table of authorities in alphabetical order. Your jurisdictional statement should just be a brief statement describing how the Supreme Court has jurisdiction in this case. Number 4, you need to include a concise statement of the legal issue. And the Supreme Court wants that stated as an appellate court would state the broad issue. Follow that with a concise statement of how the trial court decided it. This is not the spot for your argument or your spin on how the trial court should have decided it. It's just really simple. The trial court denied the motion based on A, B, C, and D. And then follow that with a list of the most relevant cases, not to exceed 4. Sometimes we see people exclude this entirely. Sometimes we see a list of 8 or 9 or 10, but limit those cases to 4 in addition to the most relevant statutes. Number 5, your statement of the case and facts. The Supreme has, or I'm sorry, the legislature has said this needs to be stated fairly and with complete candor as concisely as possible. Sometimes I think those of us who draft statements of the case and facts or see others sort of forget this aspect of the rule. But then don't forget each statement of fact needs to have a citation to the record. And we usually advise to do that after every single sentence. Number 6, your argument must contain citations to the authorities that you rely on and should avoid needless repetition. Number 7, in your conclusion, just briefly state exactly what relief you're seeking on behalf of your client. And number 8, sometimes you must and sometimes you may include an appendix. The statute is once again very clear on what you must or can include, but keep in mind, never ever use your appendix to create your record. The Supreme Court has made this clear in multiple written decisions, some even just this year. The appendix is for any parts of the record to which you want to direct the attention of the court. Do not use your appendix to create any part of your record. Jumping into oral argument, if your case is selected for oral argument, you will receive written notice. It'll be mailed to you with the date, time, location, and the length of your argument. The appellant gets to open and close oral argument, and statute says that the opening argument shall include a fair statement of the case. Your time breakdown will be 20 minutes for the appellant, 20 minutes for the appellee, and a 10-minute rebuttal for the appellant. The statute says unless otherwise ordered. You may have noticed that this current Supreme Court oftentimes likes to abbreviate that a little bit. And we've been seeing a lot of arguments that are 15-15-5 instead of 20-20-10. You are permitted no more than 2 attorneys to argue a case per side. If you fail to appear, note the statute allows the court to still hear oral argument from whoever does show. So you don't get a redo if you fail to appear. And one other note, you can arrange to have physical exhibits displayed. This doesn't happen. It doesn't happen super often, but it can really add to your oral argument when that is taken advantage of.
So I'm just going to talk very briefly about just etiquette with the Supreme Court Clerk's Office. We are happy to help with any sort of procedural questions or due dates. It's probably good practice to always call and confirm what the due date is on a brief or something like that, because they are tracking it, and it's good just to confirm that you counted that 45 days correctly. But the clerks are not attorneys. So if you have a more unsettled substantive question, know that they're not going to be able to give you any legal advice or interpret the law for you. If the matter you want addressed is substantive, file and serve a motion. I know a lot of work does get done through email in the circuit court, but that's not really how it works in the Supreme Court. So when in doubt, serve a motion, allow time for a response, and the court will consider it. And just keep in mind that when you contact the clerk's office, it is like contacting the Supreme Court itself. And if you were to receive an order, or say an order to show cause on something, and you're directed to respond to an issue, take that opportunity to make your case. It's done so that each side gets to inform the court of the facts and the law, and to get an opportunity for a response. It's for everyone's benefit to get that extra information and opportunity for argument.
We're finishing up a little bit early here, but I wanted to touch on a little bit of final advice. Number one, really don't forget to build your record. A sparse record can be the basis for the Supreme Court to affirm the lower court's ruling, and often really does so. The Supreme Court has said that in the absence of a record revealing otherwise, the circuit court is presumed to have done things correctly. You can't remedy a sparse record in any other way. You can't add stuff at the last minute to your appendix and think that that suffices. So it's really important to establish a good record. Number two, I indicated earlier, statutes are incredibly helpful when it comes to appellate practice before the Supreme Court. They're really clear. They offer a lot of guidance. If there are maybe some gray areas, I've found that notes to case decisions in your code can really assist there if you're unsure. But really don't, when you're at least formulating your appellate briefs, I make a special note to say, do not forget to reference authority for your position. This isn't like motions hearing in front of the circuit court where you're just orally advocating in an area that doesn't have a lot of support. You really need to reference authority for your position. Once again, the failure to cite authority can also be the basis for an affirmance. You are statutorily required to cite authority in your argument section, so don't miss that opportunity. And number 3, I would highly recommend that everyone author your appellate pleadings with candor. Again, appellate practice isn't like arguing your case in front of a jury. I would say approximately 95% of the time, your case is going to be decided based on your written briefs. So eliminating overly argumentative language, making sure you don't ever stretch the truth or hide any facts or law that might harm your case, I think will go a long way in ultimately remembering that your reliability, your candor in front of the court is of utmost importance, and our roles are to really assist the court in doing the right thing and making good law. And I think that's about all I've got. We'll open it up for questions. Bridget, Ryan Loker threw out a question in the chat and answered him, but you might disagree with me. So we'll see if you do. When you were discussing civil appeals, he asked if the prevailing party on a ruling neglects to file a notice of entry, does that effectively frustrate any right to appeal? And is there any remedy for the party desiring to appeal if no notice of entry is filed?
So I can't recollect any. There might be a case out there on this, but essentially if the notice of entry isn't filed, the time to take the appeal hasn't run. So you can still take that appeal. It just means that the time hasn't started running. So it's not that you can't take the appeal. The notice of entry just really is the device that sets that clock ticking. So it's I think that's the concise answer without getting too much into it. So
use it to your benefit and know that your clock isn't running yet.
Right.
Any other questions? You can add to the chat if you prefer. And thank you both for including your email addresses. If anybody would have questions afterwards, they can contact them, or you can contact the State Bar at info@sdbar.net, and we will get them directed to our presenters. Once you leave today's webinar, you will receive a survey on the presentation, and we would appreciate it if you would complete that and provide your feedback. On behalf of the State Bar of South Dakota, thank you for joining us, and have a great rest of your day. Thank you very much.